In this section, we talk about the evolution of bankruptcy law, specifically a major piece of bankruptcy legislation, the most recent piece of bankruptcy legislation, the BAP-CPA, which was signed into law in 2005. So the Bankruptcy Reform Act in 1978 provided the modern foundation of bankruptcy laws. It's the act which created the Chapter 11 restructuring process. Subsequent amendments in the 80s curtailed the power of bankruptcy judges. That notwithstanding, there were a record amount of bankruptcies in the 1980s and early 1990s, like the high-profile airline bankruptcies. They really stressed the system and resulted in new innovations like faster bankruptcy processes. In fact, the 1994 Bankruptcy Reform Act attempted to really increase the efficiency of the bankruptcy code and had provisions for the pre-pack. That's what sort of started the pre-packaged bankruptcy process, codification into the bankruptcy process. Created a National Bankruptcy Commission, which recommends further improvements on bankruptcy law. And then the latest piece of bankruptcy legislation is called the BAP-CPA, the Bankruptcy Abuse Prevention and Consumer Protection Act, signed in 2005, was a major piece of legislation. And we're going to talk in fairly broad terms about what some of the effects of the BAP-CPA were on companies. Now, most of the effects were actually on individual bankruptcies, specifically curtailing the rights of individual debtors. But there are some things that affected corporate debtors as well. So one of the major things that it changed was exclusivity. Debtors' exclusive right to file the plan of reorganization cannot be extended beyond 18 months. Prior to BAP-CPA, this period was 120 days, but was routinely extended far longer, which effectively enabled the debtor to to extract concessions, I should say, from other creditors, because they essentially had the monopoly on filing the plan of reorganization. And so without any potential competing plans of reorganization, the debtor, because the judge would routinely extend that exclusivity period, it afforded the debtor some advantages that have now been curtailed in the BAP-CPA. Secondly, the debtor's exclusive right to solicit acceptances for a plan of reorganization. This is, so once you file a plan of reorganization, you have to solicit acceptances for it. Cannot be extended beyond 20 months. Prior to the BAP-CPA, the period was 180 days, but that was routinely extended far longer as well. Executory contracts and non-expired leases. So first of all, when we talk about executory contracts, we're talking about contracts that have obligations on the debtor and some on two parties, the debtor and another party from which they're providing services over a long period of time. So the most common example of an executory contract is a lease. Borders, Borders is the case study we're going to go through, is a perfect example. They have tremendous amounts of unexpired leases. They opened up stores with 30-year leases in lots of geographic areas, and those leases have contractual obligations both on the lessor to provide the space and on the lessee to make payments over a long period of time. Well, one of the advantages of an in-court bankruptcy process as opposed to an out-of-court for a company that has lots of leases, unexpired leases, is the ability to reject, to pick and choose, individual leases in individual executory contracts, and choose whether you're going to assume those leases when you get out of the bankruptcy process or even during the bankruptcy process, or whether you're going to reject those leases altogether. Well, if you're going to assume an executory contract or an expired lease, or an unexpired lease, I should say, well, number one, in order to assume that, you have to cure the default. You have to pay the monetary losses that have been accruing since you stopped paying, presumably, that made those lease payments. And you have to provide assurance of future performance. The assumption or rejection of an executory contract or an unexpired lease is treated as a pre-petition breach and generates damages that are treated as an unsecured claim, subject to exceptions and limitations, specifically around commercial leases, which we'll talk about. But basically, the takeaway here is you can assume or reject leases or other types of long-term contracts. The damages that have occurred, so imagine you stop paying for a lease. Once you file for bankruptcy, you stop making lease payments. So those lessors are basically left not receiving any payments, and also they're not allowed to cancel the lease on you. They can't lease it to anyone else. So they're left in the state of limbo. Now, as months go by and you're not making your lease payments, the lessor can file an unsecured claim for all the missing lease payments. Now, there are certain restrictions for lease payments and exceptions that are identified below. The deadline, now, I should back up and say, if you choose to assume the lease that you basically stop making payments on as soon as you file bankruptcy, you have to reassume that lease within 210 days of filing for bankruptcy. Prior to BAP CPA, the deadline was 60 days for either assuming or rejecting the lease, telling the lessor, hey, we're going to keep going with you guys, or we're going to reject. We're going to basically, stop this lease. It was 60 days, but it was extended indefinitely in practice. Now, imagine the detrimental impact that has on lessors, which cannot sell, which cannot release to anybody else, and they're not collecting payments at the same time. So prior to BAP CPA, debtors were able to hold lessors hostage, and that kept lessors in limbo. Under BAP CPA, if a lease is rejected, so the other idea here is, so not only do you have to assume a lease within a reasonable period of time, but if you choose to reject a lease, the lessor can claim 2 years' rent as a priority claim, as an administrative priority claim. The remaining, the greater, and then this is a specific rule to commercial leases, the remaining claim, you may have 28 years left on the lease. The lessor may not claim that full, 28 years. They may claim the greater of 1 year's rent or 15% of the remainder of the lease, not to exceed 3 years' rent. So at the most, we're talking about 3 years' rent that they could claim as an unsecured claim, and that caps their claim. So BAP CPA really put some transparent, rigid guidelines about what the damages that a lessor can claim are, how those are going to be treated, and also some restrictions on what the debtor can do in terms of stringing the lessor along. Okay, pre-packaged bankruptcies, unlike prior to BAP CPA, solicitations for approval can continue after you filed for bankruptcy. Prior to BAP CPA, solicitations post-petition were prohibited. Okay, reclamation rights. Vendor rights have been expanded under BAP CPA. Specifically, sellers can now force the debtor to return goods for goods sold up to 45 days prior to and potentially 20 days after the Chapter 11 filing. So imagine you're a vendor. You provided a whole bunch of goods to a debtor that now files for bankruptcy, 3 days later. Now you have some rights that have been defined by the BAP CPA to reclaim those goods. Even if the reclamation demand was not submitted, vendors have a priority administrative claim for the value of any goods received within 20 days prior to bankruptcy. Certain limitations apply, such as claims secured by the goods a vendor may attempt to reclaim, as well as the usage of those goods. Next, employment contracts. Employee claims are limited to 1 year's salary. Fraudulent transfers. Okay, so a brief sort of hyperbolic description of what a fraudulent transfer is. Fraudulent transfers represent transfers away from the transfers typically of cash out of the company for various reasons, like paying for an acquisition or giving, issuing a dividend or what have you, that are deemed fraudulent by the estate during the bankruptcy. So the most egregious example of that is, imagine you have an equity owner of the business issuing themselves a dividend ahead of the company going bankrupt, knowing that the company is going to be bankrupt, issuing and knowing that they're going to, they as the equity owners are going to get nothing, issuing themselves a dividend ahead of the bankruptcy process, and then using that money to make a secured loan that's senior to all the other loans and all the other vendors back to that company. Basically priming everybody else, instead of being equity all of a sudden, knowing that this company is going to go bankrupt, they prime everybody and now have first position for any recovery. That is a very egregious example of a fraudulent transfer. And during the bankruptcy process, you actually have the right to review any transfers out of the estate, out of the company, and try to reclaim and try to claw back any such egregious transfers. The look back period, the amount of time that you have to look back, is 2 years instead of 1 year. There are actually finer points here. There's several different types of fraudulent transfers. There's fraudulent conveyance. There are also voidable preferences. There are sort of nuance. There's several nuances for what's considered a fraudulent transfer. But for our purposes, the takeaway here of what's happened under BAP CPA is that there's been an expansion of how far you can look back. Other BAP CPA changes, there was an attempt to curtail essentially employees, management, extracting very high salaries once they're running the company under bankruptcy. So one of the more interesting things in a bankruptcy is, believe it or not, you had the same management team that led the company go bankrupt is now sitting in place, in charge, running the bankruptcy process, presumably working with restructuring consultants and whoever. But they have to give themselves a salary, and usually the salaries in the employee retention plans are actually pretty lucrative. And so BAP CPA tried to set some limitations on how much salary management can give themselves during this bankruptcy process. Obviously, creditors were upset at these kinds of things, but management, as being the ones in charge, again, can really hijack the process if you don't give them what they want. So BAP CPA legally put some restrictions on that, although those restrictions, so I should back up. The way that management paid themselves and paid employees is through something that's called KERP, Key Employee Retention Plans. And so, since the limitations have been set on KERPs, they've actually been circumvented since 2005 by using incentive plans instead, that basically, provide similar types of attractive compensation plans, but without it being categorized as a KERP. Okay, some other changes: tax claims can be paid out over installments no longer than 5 years. Previously, that was 6 years. Creditor committees must more proactively share information with non-members in the class. And lastly, pre-petition investment bankers can stay on post-petition. This was not allowed prior to BAP CPA.